Thank you very much for having me this afternoon. Yeah, as Kirsty mentioned, I am Lauren Emmett-Lee. I'm a senior associate in the construction and engineering team at Walker Morris. Just a little bit about myself. I specialise in contentious construction matters, which probably not surprisingly involves a lot of cladding and fire safety claims at the moment, and in particular those which were brought under the Defective Premises Act, which I'll probably refer to easier slightly as an DPA, and then obviously the Building Safety Act. So I'll just popped on the screen a bit of a brief agenda, just in terms of the topics that I'm going to cover. I think it'd be really helpful just to look at the history of the DPA and kind of where it came from, based on what it's now used for, because it's had a bit of a history. And then we'll look at some of those specific sections, and then obviously look at how we can prove that and how we evidence that in claims. And finally, I'm just going to touch briefly on what we call a duty to warn, and also adjudications in DPA claims, because there's been some advancements there as well. So just looking at the history, its use of the DPA has really developed probably most over the past few years. As the name suggests, it was enacted in the 1970s, so it has been around for quite a while. And basically, its initial purpose was to try and tackle a bit of a perceived injustice where you had subsequent owners of, say, a block of flats or flat, and they were unable to bring claims against the original contractors because they didn't have a contract in place if they had issues with their property. So that was kind of where it came from. But for many years, it was what we could probably describe as a bit of a sleeping statute. It was technically available, but it was very rarely relied upon. And it was for a number of reasons, really. The key one being that it had an extremely restrictive limitation period. For those people that don't know, a limitation period is essentially a legally defined time frame within which you can initiate court proceedings. So basically the time frame in which you can bring a claim. And if you bring a claim after this time period, any defendant would basically have a defence to say that the claim is time barred. So it's quite crucial when you're looking at things that you ensure that it is within this time period. And because of this restrictive time period, it just wasn't really used, because claims under Section 1 had to be brought originally within 6 years of completion of the dwelling. And we'll come on to what a dwelling is shortly. But I think a lot of defects didn't manifest until maybe 10, 20 years later, and therefore by the time that they'd actually sort of presented, the limitation clock had already expired, so it was basically practically useless. And I think one of the other reasons is that there were a lot more familiar causes of action. So before the BSA came about, generally practitioners preferred your contractual claims, so your traditional breach of contract claims, say under a building contract or a warranty. Under those you had really clear obligations, you had express warranties that were in place, and therefore it just seemed like a bit of an easier and more familiar route. And those documents, so your building contracts and your warranties, were also executed usually as a deed. And that gives you a 12-year limitation period from practical completion. So you had a lot longer in which to bring a claim. And therefore it just seemed like the most preferred option. And also, one interesting point, given what the DPA was brought in for, is that actually leaseholders and residential owners would have probably had some sort of new home warranty in place. So whether that's something with maybe an HBC or a Premier guarantee, but they'd have had something potentially for maybe 8-10 years that they could have used instead. So it just wasn't really something that we looked at. So even though it's been around for quite a long time, for about 40 years, the DPA was rarely litigated. We have very little judicial guidance, and there was quite a lot of uncertainty about how far the DPA could go, so what its reach was and what would fall under its remit. And quite frankly, lawyers in particular prefer tools that they can predict. We like to know what we can do and what the outcome is likely to be. And therefore, something like this, an act which is legally undeveloped, or was, I should say, legally underdeveloped, is just generally avoided. So it became a bit of a niche last resort mechanism, really. However, obviously the Building Safety Act came in 2022, and this has kind of changed everything in lots of ways. But it has basically transformed the DPA from this underused statute into probably one of the most powerful tools in the building safety litigation. And this is particularly crucial for your historic developments. And it's now opened the door for new claims that were once time barred. So you could kind of say the DPA has had a bit of a new lease of life. On this limitation point, they have now introduced a 30-year retrospective limitation period for Section 1 claims. And that relates to all of your work which was completed before the 28th of June 2022. So it applies to all the historic projects. But not only that, they have also introduced a 15-year prospective period for works completed after the 28th of June 2022. So this applies to all your future projects. And this basically means that a lot of claims that were originally time barred due to the very restrictive limitation period originally, and some of these can be decades old, they can now be pursued. So it really has opened the door in that respect. And what it has also done is it has introduced a new Section 2. And this now means that any work undertaken for refurbishment, renovation and remediation now falls within the DPA duty. So it no longer just applies to your original construction. This is a legal point, but one point I think it is worth remembering is that the DPA is a statutory obligation. It cannot be contracted out of or restricted in effect. So it applies regardless of what contractual terms are entered into. And because of that, it's a really useful tool that we can use in pursuing claims. Just firstly, looking at Section 1 of the DPA. I will touch on Section 2A, which is the new one, briefly, but this is sort of the main focus. So I've popped the wording on your screen of the actual wording and highlighted the relevant points. So this basically applies to any person who is taking on work for or in connection with the provision of a dwelling, and we'll look at what that means. They owe a duty if the dwelling is provided to the order of any person, they owe it to that person, and to every person who acquires an interest, whether that's legal or equitable, in the dwelling. And the key bit is that they need to ensure that any work which they take on is done in a workmanlike, or as the case may be, professional manner, with proper materials, so that the dwelling will be fit for habitation when completed. So we can break that down into 4 key points or questions that we need to look at. So firstly, who is the duty owed to? Secondly, what is a dwelling? And then we can look at who owes this duty. And then, as I say, crucially, what we need to demonstrate in order to show that either the work was or wasn't completed in a workmanlike manner or professional manner, using the proper materials so that it was fit for habitation. And all of that coming together obviously is our way of demonstrating that this particular building, for example, has or hasn't breached that duty. So looking firstly at who the duty is owed to, there's basically two limbs to this. On the one hand, the duty is owed to someone for whom the dwelling was provided. So that is typically your original client, your employer, your developer who engaged the contractor. It's on that side. And then the second limb is those that acquire a legal or equitable interest in the dwelling. So this is your freeholder, your leaseholder, and any subsequent purchaser. So that's obviously the bit as to why it came in originally. And there's no requirement for there to be a contract between the parties here. So the duty just applies anyway. And there was actually a recent case on this that was heard in the Supreme Court last year, and this is a case called URS v BDW. And this has basically concluded that a developer, for example, may be simultaneously owed a duty under the DPA because they were the person who ordered, I suppose, the building of the building, but they can also owe a duty under the DPA because they arranged for the works to be undertaken. And that duty would be owed to, say, your leaseholder that bought their block of flats. The second point that's really crucial, I think, is what is a dwelling? Because the DPA only applies to the provision of a dwelling. And the dwelling is not actually defined in the DPA. But I think it goes without saying it includes a house, and it excludes any sort of commercial premises. A lot of the time, we'll obviously look at blocks of flats, and that's obviously been in the news a lot recently. And in relation to blocks of flats, the courts have said that a block of flats is a building that contains a number of separate dwellings. So the block of flats isn't actually a dwelling itself. It just contains a number of separate dwellings within it. And those non-living spaces, so your common parts, do not form a dwelling. However, this doesn't exclude your common parts from falling within the section, because what we can say, looking back at this, is that although they don't form part of a dwelling, the common parts, such as your foundations, your structural walls, they may still constitute work, and it's this wording here, work in connection with the provision of a dwelling. And it's that point that it sort of pulls in your common parts. There was a case on this in 2014, which was probably the leading case on the DPA interpretation. And the case, if you're interested, was called Rendlesham Estates v Barr. And it would be negligent of me not to flag that was a Walker Morris case that we ran a few years ago. But that has said that to fall within the broader category, the common parts must be either physically or functionally connected with the relevant dwelling. And I think when you're looking at big blocks of flats, it kind of goes without saying that your external walls will fall within that remit. But in each case, it is very fact specific, and it's important to look at whether the apartment owners, the leaseholders, have a financial responsibility for the maintenance and repair of the common parts, and also whether they have a right of access to the common parts. So if they need to pass through various areas of the common parts in order to reach their apartments, then it's probably likely to be covered. There has been a few questions about student accommodation and retirement homes and whether they contain or constitute dwellings. And I would say this would turn on the facts of each case, but generally speaking, student accommodation is regarded as a dwelling. You'd need to look at, obviously, the arrangements that were in place. So do they have an individual address? Do they contain the essential features for living? So sleeping area, washing area, eating area. Are they separately accessed? And things like that. But generally speaking, student accommodation at the moment is under the DPA. A retirement or a care home is not quite as clear. And I think, again, it would depend on the facts and also the nature of the accommodation. If you have a care home, which is an individual residential unit, maybe a sort of sheltered living arrangement where you have residents have their own private space, but there is care available if needed, that's likely to fall within the scope. Where it gets a little bit unclear is if you have communal facilities. So, for example, it's either a hospice or probably more of a traditional care home where residents only have a bedroom and then they share the other facilities. That's maybe less likely, but it would depend on the actual circumstances. So the next question we need to look at is who owes this duty? And this is basically a question of whether someone is taking on work. And again, it would depend on the facts in each case. But generally speaking, the way we analyse this is we look at who does work which positively contributes to the creation of the dwelling. So I think it's quite obvious that that includes your contractors, because they physically take on work which constructs the block of flats or the house, so it constructs the dwelling. But we can also include architects and fire engineers where the role is positive. So those professional services basically influence whether the dwelling is fit for habitation at completion or not. And it depends on sort of the circumstances in each particular case. But on the flip side to that, if you're not taking on a positive role, such as a building inspector, where actually you're just inspecting for compliance with the building regulations, then that wouldn't be covered. And then the final point we need to establish, which is the most crucial, is whether this work was undertaken in a workmanlike or professional manner with proper materials. And this is where the expert evidence is crucial to supporting and evidencing the claim. It's a single duty, so it is one complete sentence, basically. Not only do you have to establish that there was a failure to undertake the work in a workmanlike or professional manner, but we also need to show that as a result of that, these dwellings were what's called unfit for habitation when they were completed. Now, the first aspect, which is your workmanlike, if I just pop back to this word, is your workmanlike or professional manner with proper materials. Usually, we can demonstrate this by considering whether the works complied with building regulations or any other standard in force at the time of construction. And that's an understood universal way of demonstrating this. And this is obviously where the experts come in. We, fire engineers, and we need you to play a kind of central role in assisting us to establish that liability. And then from that, the causation and the quantum of any remedial scheme. This is a very technical aspect, I suppose, of the compliance, and therefore we need to understand from your input well evidenced technical analysis that we can then use to build the claim, applying sort of the relevant legal bits and the case law. And personally, I find this the most interesting. It's the other bits you can kind of, it is what it is. But this is the bit that I enjoy, is getting into kind of the nitty-gritty detail of each particular case. And I have spent many, many hours going through everything with experts, asking questions. It's all very complex, and there's obviously a lot of learning involved, and you learn all sorts about test data and everything. But it's the bit that we need the most assistance with. And more often than not, this is crucial to the success of our cases. Without this, we wouldn't get anywhere. And without the correct analysis, we'd be in trouble. So just before we go on to look at this more technical analysis, I did just want to mention that, given the audience, I have focused on fire safety defects, but just a point to remember is that the DPA doesn't just apply to fire safety defects. It also applies to anything which basically renders a dwelling unfit for habitation. So it can include things like damp and mould or structural issues. They would all fall within that remit. So the second aspect, once we've looked at the building regs, is we need to show that the dwellings were unfit for habitation. Now, it's a funny wording, but it's basically judged at the date the work is completed. So, but even though it's judged at that time period, just because you couldn't see that those issues were there, doesn't mean that it was fit for habitation, I suppose. But the test, which also came from the Rendlesham case, is that on completion, the dwelling must be capable of occupation for a reasonable time without risk to the health and safety of occupants and without non-trivial inconvenience or discomfort. So just a few examples. To be fit for habitation, the dwelling or apartment, I suppose, must be reasonably occupied by all types of people. So that would include babies and those that suffer from something maybe like asthma. And one of the ways that we can demonstrate this is by looking at the time of completion. If the state of an apartment is such that a local authority with knowledge of its condition would not approve it as fit for occupation under the building regs, then it's probably unfit for habitation. So if you can demonstrate that the way a building was constructed did not comply with the building regulations, you're kind of halfway there, because once you've been able to establish that, you then just need to show that, well, if the local authority had known at the time that this apartment didn't comply with the building regulations, they would not have approved it as fit for occupation. So they wouldn't have gone on to sign, obviously, a building reg certificate and everything that follows. And in those circumstances, it's likely that it's unfit for habitation. And one of the I think sometimes people can get a bit het up on this, is that just because something isn't costly to remediate, so even if it can be remediated at a relatively modest cost, that doesn't mean that there's no breach. You can still have a breach. It doesn't need to be a multi-million-pound remedial scheme in order for it to constitute a breach of the DPA. This is just, a measure of damages. And just on another example, which isn't fire safety related, if something causes a serious inconvenience, that can also make a dwelling unfit for habitation. So the example I have is if you have a lift in a tower block that was really poorly installed and it was regularly breaking down, the apartments on the top floor are likely to be unfit for habitation because that's a serious inconvenience, particularly if, say, for example, it was a disabled person that was living there, then obviously the dwelling wouldn't be fit for habitation for all types of people. And that's something that needs analysing and looking at. So those two elements go hand in hand. And I'm going to consider them both together. But just before I do, I just want to briefly touch on this section 2A. So this is another section of the DPA. And this was introduced by the Building Safety Act. And basically what this has done is extended the DPA so that it now applies beyond original construction. And there was originally a bit of a gap there as to whether when you undertake refurbishment or renovation, you were covered under a DPA. And this new duty now means that anyone who undertakes refurbishment, renovation or conversion or any other work to a dwelling that already exists, you have to comply with this obligation, and again, ensure that the dwelling is fit for habitation. The wording you'll see is actually pretty much the same. The only slight difference is there's a few extra definitions of relevant building, and then it says that it needs to be done in the course of a business. So it excludes someone who is just carrying out some work to their house or someone else's house. So if I went to do some work at my friend's house, I wouldn't have to comply with this. It is, as I say, very, very similar in wording to section 1. The only difference here is that when we look at the limitation period, it doesn't apply retrospectively. So this section will only apply to work that has been done after the 28th of June 2022, and you've got a 15-year limitation period. So this doesn't go backwards like section 1 does and looks at your historic defects. So I think the key question, once we've sort of been able to analyse what we need to understand, is how do we prove this? And this is a very expert-led process. We need to consider, whether there's poor workmanship, design defects. And generally speaking, there is no fixed rule on how we demonstrate that defects are present, and also, probably more importantly, how widespread they are and what their extent is. We just need to satisfy a court or an adjudicator that they are there on the balance of probabilities. And I think the starting point when we look at this is, okay, well, what information do we have? What information about the design and construction do we have? Now, this is obviously quite tricky on some historic projects, but you'd be surprised what people find in basements of flats. We need to see what design information we have. Do we have the O&M manuals from the original construction? Do we have as-built drawings? Do we have any photographs that were taken during the construction? Do we have any site reports? What contemporaneous correspondence do we have? Were there any progress reports that were done? Was there any sort of QA procedure that was done at the time? Is there anything that we can use to paint a picture of the actual design and construction of the buildings? And this then leads us on to the next question of, well, what site investigations do we need to do? And this basically depends on the circumstances, because if you have a situation where you have lots of as-built drawings, you've got loads of O&M information from the original construction, you've got a full suite of documents, you may or may not have photographs during the construction, but you've got a lot of information which you can use to analyse what the design was at the time. we can then probably say, okay, well, actually, we only need to do a modest amount of site investigations because we think we know what the design was. All we need to prove now is, okay, what was actually constructed was either consistent with a defective design or it wasn't. And that's just that extra step that we need to show, well, what was actually built based on the design drawings. The difficulty is if we have no design information. This obviously means we need to do further investigations to try and establish whether defects exist. And as I say, more importantly, what the extent of those defects are. And it will depend on really just what is available and what we can use. One of the other points is it's all okay, if we've got loads of information, but when we actually start opening up, say, for example, external walls, we discover that what wasn't built wasn't anything like what was designed, and that can either be in a good way or in a bad way, and it's that extra step that we need to look at. In terms of opening up works, the best way to demonstrate this is to open up in a broad range of locations. I know many people, and we've had the same problem, have issues with access. That is an ongoing problem, I think. I don't think anybody likes it when you come along and try and take apart their external walls, understandably. But once those locations have been identified and we begin the process of the opening up works, obviously that is a process that needs to be assessed as we progress. It's fine for us from a legal perspective if, as you start to carry out investigations and take apart the external walls, a clear pattern starts to emerge, then that might be sufficient. We don't need to go any further. As I say, nobody wants anybody to come along and start taking off all of their external walls, and it's not cost effective to do so. And you end up with all sorts of problems of what do you put back. But obviously the difficulty is if there are no clear patterns, then we may need further investigations and further opening up works to try and establish what was actually there on the site. There has been some case law recently about sort of the extensive investigations over the past few years and what people have looked at in terms of what is suitable. And, in some instances where if you're engaged with the defendant and you go on site, recommend areas for opening up, the defendant's experts recommend areas for opening up, goes without saying, you agree on areas, you go to site, you look at those areas, it seems to be that the issues are consistent across the site, then, courts are willing to accept that that's actually probably a fair representation of what was actually built. There's no expectation for you to take the whole external wall off, none at all. It's just a case of looking at what documents are available, and if there aren't a lot, it may be that further investigations are needed. I think the court's position generally is that they will look at this as a whole in order to arrive at a decision based on the presence and extent. I think it's just important to mention the extent point. As I say, if you can agree an area or a set of areas, and as you're going through those areas, you sort of identify that, this is a common theme across the development, it is reasonable to assume that that is the case. But it is just important to look at the extent, because, as I'm sure you can all probably tell me, one issue in one area of one elevation isn't going to get us over that hurdle of your fitness for habitation. And there's no prescribed way in which we need to demonstrate the findings. All that we need is something which is detailed, has some logic in terms of the formatting, and that is really clear that we can use as evidence. So once you've undertaken these initial investigations, the next stage is analysing, and it's analysing in a way that we can understand. So firstly, looking at compliance. We need to understand, because as I've said, the DPA applies at the time of construction. So we need to understand what the legal framework was that was in place at the time of construction. So what were the applicable building regulations and the applicable approved documents that were in place at that time? And then on the same point, I suppose, is what do we know about the fire safety provisions? So was there a relevant fire strategy at the time of construction? Do we know about that? Do we have any documents on that? And do we have any evidence of any alternative routes to compliance? Is there any evidence of a fire test route? Is there any evidence of an alternative fire engineered solution? Or is it reasonable, based on the lack of evidence, for us to conclude that it was probably a linear route to compliance? And this is all kind of links to the analysis, I suppose, of all the documents. And then alongside this, we need to understand what the design was. We need to understand whether the design complied with the relevant building regulations and the approved documents. And then obviously following on from that, we need to understand the as-built position. And this is where the extent of the investigations coming. And we need to understand if there has been any deviation from the design, for better or, as I say, for worse. And in terms of the external walls, it's in as much detail as can be provided that we need in order for the position to be clear. Now, the non-compliance with the building regs, it's not an automatic DPA breach. As I've said, whilst it's really persuasive at getting you over the initial stage of workmanlike or professional manner, we do still need to demonstrate that this has led to an unfitness for habitation. But I think the building regs point is really persuasive in terms of if we can demonstrate that there has been a material deviation from the approved documents, or if there's been a material deviation from any accepted fire engineered solution, if that's in place. Then, as I say, this links directly to the life safety risk point and the unfitness for habitation. And actually, I suppose on the flip side of that, if we could say that, well, actually, if you'd have complied with the building regs or approved documents, it would have avoided the defect completely, then that's a strong position. And I think, as I've mentioned, the DPA applies to dwellings, and that always needs to be kind of in the back of your mind in terms of how the analysis is presented and how we look at that. So just on the fitness for habitation assessment, as I've said, that there's so many factors that can be taken into account when you're trying to demonstrate an unfitness for habitation. I think one of the good example in terms of an external wall is that, as I've said, we have case law which says that if the local authority had possessed knowledge of the condition of the dwelling, so the condition of the apartment, the local authority would never have approved it as fit for occupation under the building regs. So in those circumstances, we can probably conclude it was unfit for habitation. And I think in terms of an external wall, if you have combustible materials, which, following the analysis of building regulations at the time, we can conclude that they didn't comply. In a block of flats where you've got your flat, which is more likely than not adjacent to an external wall, and then wrapped around or enveloped, I suppose, by these external walls. And if those external walls contain materials which are going to present a medium for fire spread, then I think it's reasonable to conclude that there's going to be a health and safety risk. And this is likely to mean that we will pass the threshold of unfit for habitation. Now, I think, excuse me, that it is an interpretation of the law, and we do appreciate that. But in some instances, you may have materials that mean it is not just one issue alone which gets you to that health and safety risk. It may be that it is looking at all of the external wall and all of the external wall materials holistically that are sufficient, cause a sufficient risk that this renders the dwelling unfit for habitation. And it's that kind of extra analysis that is really helpful to understand. And the question is, it's really all about what is the risk which is posed to the occupants of those dwellings. And finally, the remedial options and costing rationale. Now, appreciate costings sit with QS, but I think where remedial works are yet to be undertaken, we do need assistance in determining what are viable remedial strategies that would achieve compliance. And, effectively, put really simply, what can we do about it? So if we, can present, this is the position that we have a breach of the building regulations, this is a risk to the health and safety of the occupants, and this is what we need to do about it. And I think it's really helpful if we can understand that. And we also, as things kind of progress, or you might end up in engaging with defendants on various points, they're going to propose essentially alternative remedial schemes. And it's a case of interpreting and understanding those proposals that they've put forward. Will they achieve compliance? Is that an alternative way of doing it? And what are the risks of those alternative proposals? And just finally on the reasonableness, there are a lot of instances where we are looking at historic developments. Remedial works may have already been undertaken, and therefore, rather than advising on a compliant remedial scheme, we need to look at, okay, well, what was the scheme that they did implement? Was that reasonable, considering the risks, the non-compliance with the building regulations? Is that what they did, was that the right approach? And I think that's another really crucial point. Just finally, as I said, I wanted to touch briefly just on this duty to warn. Now, I won't go into great detail about it, but you can see obviously the wording of these sections on the screen there. And I won't read it out, but basically, in short, these sections do provide a possible defence to a DPA claim, effectively by saying that the defendant was just following instructions. So if a party can say that they, and the wording is properly, followed instructions, they can effectively be deemed as discharging the duty that was imposed on them in the subsection 1 that we've spoken about. Now, I think this is very fact specific in the circumstances. Whether it can apply would probably depend on what type of contract was in place. So if you have a design and build contract, which is obviously a very common arrangement, where the design is effectively carried out independently from, say, any instructions from employer's agent, you're unlikely to ever be able to say that you can benefit from that defence. But if there's an alternative situation where you may have a contractor under a JCT standard building contract, where they have a duty to comply, it's a bit trickier. But I think the point on this that is, whilst that might be in place, there is one express exception to this, and that is that there is a duty to warn. So the defence of following instructions isn't going to protect someone where you should have warned of those defects, or you should have warned of the steps that you were taking, and you should have said they're not going to comply. And if you fail to do that, then there is that obligation is still there. And I think it's important on that point is I think it's quite common sense. If you're not happy with something, it's really important that that is flagged and records are kept of that. And it's just about exercising, professional judgment. And if you're not sure that something is going to comply, then making that known. And the final point I just wanted to mention was that some of you may be familiar with the process of adjudication. However, there was a new case, can't quite recall, I think it maybe was last year. Again, it's BDW Trading and a case called Ardmore Construction Limited. And this has basically concluded that DPA claims can be referred to adjudication. It was quite a bit of a development in terms of how you procedurally bring a DPA claim, but it has quite big effects because it means now that there are quicker ways of dealing with these claims, and it's also cheaper. You don't have to go through the long process of litigation. You don't have to go, through all the court trial process. There is a mechanism now in place where we can deal with this by way of adjudication. I suppose the downside of this is that we may get less judicial authority on the interpretation of DPA. So there'll be less cases going through the courts. So we'll have less sight of what decisions find their way there. But I think it does show that this act is really going to be more widely used. And the fact that they've tried to find a way of dealing with these types of claims quicker and cheaper, not only does it, I suppose, free up court time, but it does also mean that they become a bit more accessible for people. And finally, just before I ask if you have any questions, I just wanted to recap on a few points that I've mentioned. The DPA, as you can probably see, has evolved from very little used statute to quite a powerful tool. The DPA is also a mechanism by which you can bring what's called a building liability order. Now, I will not get into that today, but that was something else which came out of the Building Safety Act. So it's sort of cropping up in lots of different ways. So I think it's crucial that we do all understand how we use it. The BSA has obviously reshaped its relevance, and as I've said, it has a bit of a new lease of life. The new limitation periods and the widening of the scope to now include these refurbishments means that there's a lot of claims out there, I suppose, in relation to your historic defects, because you can now go back 30 years, which is a long time. And I think the implications of this are really significant, and legal profession and all of the experts and that profession is really crucial to us establishing compliance. And then obviously what follows on from that is your causation and your risk. And as solicitors, we rely on expert evidence heavily. We need that assistance to interpret designs, as I say, assess compliance with the building regs, and then that extra step in the DPA to say whether those defects create a health and safety risk for occupiers. And I think it goes without saying that because of that, where we have well-reasoned expert analysis, this is often the determining factor in whether a DPA claim succeeds or not. So I think it's really, really crucial in relation to that. That's all from me, but if anyone has any questions, please do let me know, and I'm happy to answer any.